We start with a no-show. In court, silence isn't mysterious. It's expensive. When a defendant doesn't show up, the judge doesn't wait. She acts. Watch what happens next.
Good. All right, his bond will be forfeited for...
On forfeiture means the court takes the money securing his release because he didn't appear. But notice the judge leaves a lifeline open. If he walks through that door today, she'll reverse it. This is firm, but fair in real time.
Non-appearance and reset at $100,000. He did call, say he was having issues. If he gets here late, then I'll obviously recall that bond forfeiture.
Okay. And Judge, like I
You've
said,
got Caris Antoine. Oh, go ahead. I'm sorry.
he did call this morning. When I tried to call him back to his house number, he was already gone, so I'm assuming he is trying to...
Maybe on his way. Okay, thank you. And then you've got Caris Antoine, Mr. Lewis.
Yes, ma'am, Judge.
Are we? Okay. You're Caris Antoine? And this is cause number 24 DCCR 1878. It looked like I did sign an order back in May for CPS records.
You did, Judge. We contacted them this past week asking for an update. They hadn't gotten back with us yet.
Okay.
I even had Mr. Hoppower call because he's used to dealing with them.
Right.
And he did that for me at the end of the week.
This part shows how slow cases can move when agencies like CPS have records involved. A lot of people think the defense or the judge is dragging things out, but sometimes it's just bureaucracy, moving at the speed of a coffee break.
They hadn't replied yet.
All right, we'll reset that just another 30 days. If you'll make a sticky note for us, we'll try to contact them as well and see if we can. Sometimes that helps to get things moved
So
along.
reiterate what you said. I spoke to them by email. Stephanie
Okay.
Adams, but we still haven't received those records.
And she didn't give any update on when we
She
could
didn't give me an
expect them?
update, but it was Friday.
Okay.
when I got last contact.
She's usually pretty responsive.
Yes.
All right, so Mr. Antoine, stay in touch with Mr. Lewis. He'll let you know once he gets that information so you can go in and go over it with him. And then we'll try to get an announcement, hopefully if we get that before the next court date.
Thank you, Your Honor.
Thank you.
And off the record, I'll show you their email reply to Mr. Hoppower's voicemail. Sound about right? Isn't it funny?
He's giving you a hard time without saying anything.
I know, I understand. It's okay.
You can handle it.
Dick scan.
Mr. Rojas, you've got Carnell Beard. Good morning, Mr. Rojas.
Morning, Your Honor.
Good morning, sir. Are you Carnell Beard?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
He would, Your Honor.
Are we going on count one? Oh, no?
No, ma'am.
Okay. Okay, let me, all right, and he'll waive the formal reading of the indictment.
He will, Your Honor.
Mr. Beard, you're charged with the third-degree felony offense of collision involving serious bodily injury from September 28th of 2024. Your indictment also alleges that you were previously convicted of attempted murder, second-degree felony, August 30th of 1999, and after that was final, you were convicted of possession of a controlled substance, a first-degree felony. Well,
Judge, I'm
do we
looking
just
at
need
the
to go on one, or
Let's
is
just
that?
go on one because I'm looking at the dates and they do overlap, so it would not make them
It
habitual.
wouldn't,
It'll
so it
be
makes it a second-degree
second-degree,
felony.
Your Honor.
So what that means,
This is called a punishment enhancement. Past convictions don't disappear, they follow you into the next case. So a charge that's normally lower suddenly gets treated like something much more serious. Prior history is the multiplier.
sir, is that the punishment range in your case would be enhanced to that of a second-degree felony, which is between 2 to 20. Do you understand?
Yes, ma'am.
And how do you plead to that charge?
Yes.
And is that prior offense true?
Yes, ma'am.
Okay. Did you enter your plea of guilty and true freely and voluntarily?
Yes, ma'am.
And did you plead guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 10-year deferred adjudicated probation. There would be a $1,000 fine, and there would be restitution ordered as determined between now and when we come back for pre-sentence, through a pre-sentence report. Is that your understanding?
Yes, ma'am.
Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Beard is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you, your case. We'll also get that restitution amount determined, and then we'll come back later for sentencing. When you're on your way out of the courtroom today, you need to stop and talk to probation, and she's at that desk right there. All right, we'll see you back at sentencing.
Thank you, Your Honor.
And then you've got Zachary Turner, Mr. Rojas. Good morning, sir. Are you Zachary Turner?
Yes, ma'am.
And this is 24 DCCR 2197. And Mr. Turner, you're charged by indictment in this case with the first-degree felony offense of fraudulent use or possession of identifying information from April 22nd of 2024. Your indictment alleges that you were previously convicted of unlawful possession of a firearm by a felon, a third-degree felony, September 29th of 2014, which means that this, for punishment purposes, would be enhanced, but
15 and 99 is the way we indicted, Judge.
right.
Given the rejection of the state's offer today, I believe we can make him a habitual, and I will be filing a habitual offender notice in this case.
So, and you've gone over that with Mr. Rojas, correct? And so I want to make sure you understand that if the state files that notice of enhancement with another prior offense, which I would assume you have since the one I see is an unlawful possession of a firearm by a felon, that means that if you go to trial and you're found guilty.
Oh, this is the moment everything shifts. The state is signaling they're ready to classify him as a habitual offender. Once that happens, the minimum sentence jumps to 25 years, meaning rejecting that 15-year deal today isn't just confidence, it's a gamble with decades.
The minimum punishment would be 25 years up to 99 years or life in prison. Do you understand?
Yes, ma'am.
And I have a plea bargain rejection here that has your signature on it with Mr. Rojas's that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 15-year term in the institutional division of the Texas Department of Corrections. And I would assume that would be going on count 1 only.
That's right.
And so you have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are and what your options are. And do you understand all of that? And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
All right, we'll get that done. Mr. Turner, Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and I can appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you? So, Mr. Rojas, you're released. Mr. Turner, if you'll just have a seat here in the courtroom, I will appoint someone. The clerks will call you up in just a minute with that information on who your lawyer is going to be. I also want to make sure you understand that after today, I will not accept this plea agreement. Once your case gets put on the trial docket, it either goes to trial, or if you change your mind, you can plea open to the court or to some different plea agreement, unless there is new information that your attorney or the district attorney's office receives. Do you understand? Okay. If you'll just have a seat, she'll call you up in just a minute. Mr. West, you have Michelle Johnston. Good morning. Michelle Johnston.